Hello students, how are you? I hope you are doing great. So let's get started with a new topic today, which is also a very important topic. So if you remember, in the last lecture we have studied the very important provision, the constitution of the company, the charter of the company, that is memorandum of association. So now we are going to talk about the second very important document for a company form of business. The name of the document is Articles of Association. Articles of Association. So this particular Articles of Association, in the short form we can say that AOA. So going forward, when I will say AOA, it means Articles of Association. So what is exactly mean by Articles of Association of the company? So students, when we discuss about Memorandum of Association, it is the public document for the outsider. So when a company deals with the outsider, it is presumed that the outsider is aware about the contents mentioned under the Memorandum of Association. It is a very important document for outsiders to go through. So once they decide to do kind of business with the company, it is their duty to go through the document carefully. So it basically defines the relationship between a company and the outside world, because it is a kind of charter or constitution. But the Articles of Association mainly talks about the internal management regulations. See, company has to manage internally very well as per the due process of law and the Companies Act and the rules framed thereunder. So it defines the working style, or it defines the working regulations for the internal management of the company. So with respect to the share capital, you can say about the board of directors meeting or general meetings, how to use the common seal. All those provisions can be incorporated in the Articles of Association of the company. So basically it talks about the affairs of the company by way of defining the powers of its officers, and it may establish a contract between the company and the officers, and between the members per se for that particular reason. So where exactly this AOA is defined, under which particular section? So it is defined under section 2 subsection 5. So the definition of AOA is given under section 2 subsection 5, which defines as articles means the Articles of Association, I am using the short form, of a company as originally framed or as altered from time to time, as originally framed or altered from time to time, or applied in pursuance of any previous company law or of this act. Any previous company law or of this act. So what does it mean? Articles means the Articles of Association of a company as originally framed or as altered from time to time. So originally frame means when a company goes for the incorporation, we have studied under the process of incorporation that a company, the proposed company, has to give the draft articles and the memorandum, which should be duly signed by the subscribers of the company. So that is originally framed. So it is not a rigid document, it is a flexible in nature because the shareholders may change the provisions or the regulations maintained under the articles of association, and that is the reason as altered from time to time or applied in pursuance of any previous company law or under this act. So the companies which were recognized under the 1956 Act, when they incorporated this or when they framed this particular document, that is also recognized, or under this act, whichever companies will go for registration, okay, such documents will be recognized. So let's talk about articles of association importance. So what is the importance of articles of association, or you can just say important points? Important points of articles of association. As we have studied the important points, if you remember, of MOA, that is Memorandum of Association, we need to now study the important points relating to articles of association. So what is articles of association? You can say, so it is companies, bylaws or rules. It is companies, bylaws or rules, you can say. But why these bylaws or rules are there? To govern. So I can put this in the second point. Okay, so it is companies, bylaws or rules to govern management of the company for its internal affairs and the conduct of its business. I will first write down all the points so that you can understand this very well. It defines powers of its officers and also establishes a contract between the company and its members. AOA plays a subsidiary part to the MOA. AOA plays a subsidiary part to the MOA. Anything done beyond AOA will be considered to be irregular. Will be considered to be irregular. Six point I can put down. Contents of AOA may differ from company to company. Contents of AOA may differ flexibility is allowed to adopt AOA within requirements of company law. AOA will have to be conversant with MOA. Last point. In case of contradiction between AOA and MOA, which one will prevail? MOA will prevail. The last point, enrichment provisions can be incorporated under AOA. Okay, so these are some of the important points. Okay, we are going to study the important points of AOA. So basically the provisions are given under section 7 of the Companies Act for articles of association. So which are the important points? The companies, okay, so first point, okay, we will discuss, it is the company's bylaws or rules. So we have already discussed this point. It is nothing but a kind of bylaws or the rules for the internal management of the company. So it is nothing but bylaws or rules for the internal management of the company. So to govern the management of the company for its internal affairs. Okay, so why these bylaws and rules are framed by the company? Because it wants to govern the management of the company. For what? For internal affairs and the conduct. So how to conduct the business of the company, everything can be defined. So students, if a company, I'll give you just an example of the private limited company joint venture. So if a company goes for the joint venture, company has to enter into various documents. Like if the joint venture company is established, two shareholders group, they enter into various agreements like shareholders agreement, they may enter into joint venture agreement, and in such agreements they may put clauses, so relating to restrictive covenants they can put. So such clauses or restricting covenants can be incorporated as a part of AOA. because whatever their understanding was before incorporating a joint venture, they can just have those clauses to be a part of articles, because it is nothing but how the internal management or the conduct of the business of the company, okay, should be. So all these particular rules and regulations can be a part of the articles of association. What does it define? It further defines the powers of its officer. So CEO को क्या power मिलेगा? So it may define the powers as well, and it also establishes a kind of contract between the company and its members. Try to understand, because all the rules regarding the internal management are defined, and that is the reason the law only will create that contract between the company and the members. So anything, okay, which will be questioned in the, okay, court of law future, so the members can take the recourse or take the reference of the provisions or regulations mentioned under articles of association. So it is so important document. AOA plays a subsidiary part to the MOA. I'm going to talk about this, okay, as I told you when I taught you MOA, Memorandum of Association. MOA is the primary document. It is nothing but a constitution of a company. It is a charter of the company, and the other part, that is a subsidiary document, is AOA, that is Articles of Association. So always it will remain a subsidiary document, because the very constitution of the company is based on the Memorandum of Association. That is what we have studied in the previous session of MOA. So anything done beyond the MOA, we have studied about the doctrine of ultra virus, which we will talk in detail little later. So anything done beyond the MOA, Memorandum of Association, will be considered as a void, ultra virus, beyond the powers. But that is not the case with the Articles of Association. That is my next point over here. I have written anything done beyond the AOA will be considered as irregular and not void directly. So what is meant by irregular? So irregular means if anything done beyond the articles, like I can give you one small example. Let's assume that a CEO of the company, that is Chief Executive Officer of the company, has been empowered to create a fixed deposit of rupees 5 crores as per Articles of Association. But he goes on and create a fixed deposit of rupees 10 crores. Now what has happened in this particular case? He has breached the regulation, or he has exceeded his power given under the Articles of Association. So this particular act of the Chief Executive Officer will be considered as irregular. It is not a regular act. Why? Because he has not been empowered to create 10 crore rupees of FD, that is fixed deposit. So now, whether this act can be ratified by the shareholders? Yes. So we can say that it can be ratified. It can be ratified. By whom? By shareholders. So students, please pay attention. So anything done, company is doing, going beyond the object clause of the MOA, can be ratified or not. I had given you an example when I taught you the Memorandum of Association. Let's assume that a company is into the manufacturing of wooden furniture, but companies goes on entering into a contract for the software development business. Now, when we read the object clause of that company carefully, we come to know that company cannot do the business of software development. So in that case, whether my act, whether the act of the company is ultra virus or not, yes, it is ultra virus beyond the powers. But after committing this particular act, whether shareholders can ratify that particular act, answer is no. So anything which is done beyond the powers given in the company's object clause if anything, the act is ultra virus, it cannot be later on ratified by the shareholders. That is very important part. To shareholders, okay, cannot ratify the act which is committed beyond the powers given in the object clause. So that cannot be ratified. That you need to remember. But yes, that is the opposite rule which is applicable over here, is that the act which is done, okay, beyond the powers under AOA is irregular and not directly void in nature, because the power is given to the company to ratify that act later on. The contents of AOA may differ from company to company. The contents of AOA may differ from company to company. Okay, so there is a table H, table F to J. Okay, given under Schedule 1 of this company law. Okay, and table A to E are given for the MOA. So these are the standard formats which a company can directly adopt. But still we can find the differences because each company may have its own way of working, and that is the reason, okay, the AOA terms may differ from company to company, so that flexibility is given. So the next point is that only, that flexibility is allowed to adopt AOA within the requirements of the company law. As I told you, if a company wants to go for table F to J, company may do it. If it is the specified type of company can directly go and adopt that particular, okay, draft of articles. But okay, what kind of flexibility is given? Company may have its own articles of association which may differ from company to company. What does it mean? Okay, see, in case of the memorandum of association, we have a set, okay, clauses like name clause, register office clause, object clause, liability clause, capital and subscription clause. But in case of articles of association, that flexibility is given, that you decide which all contents you want. But of course, the main important contents like the Companies Act contents should be there, or company may decide to incorporate their kind of understanding between the shareholders in the form of articles of association. AOA will have to be conversant with MOA. It should go hand in hand. So you cannot have any particular provision which will go against the MOA. In that case, what will happen? In case of contradiction between whom? MOA and AOA, what will happen? Who will prevail? That is MOA which will prevail. So normally there should not be any kind of contradiction, but it happens, okay, that okay, in contradiction is not noticed. In that case, MOA will have to be read carefully. So MOA's provisions will be applicable and not AOA. So these are the important points you need to remember. The last point, which is little bit different, which is called as enrichment provision. What is meant by enrichment? See, the restrictions can be laid down under AOA, Articles of Association. So which kinds of restrictions? Like normally the majority of the decisions will prevail in case of board resolution, and there can be special resolution and all those things. But here few resolution, okay, can be passed. For example, in the private limited company, okay, with 100% of the, okay, approval. And in case of the public limited company, special resolution. So such kind of enrichment provisions can be mentioned in AOA. What does it mean? So let's assume that a company is going for a joint venture. Okay, ABC Corporation, United Kingdom, and XYZ Private Limited Indian company is setting up a third party. Let's assume that, which is E Private Limited in India. Now the ABC holds 30% of the stake, and the XYZ holds 70% of the stake. So it is very crystal clear who is going to take the majority decision. XYZ. So in the board of directors meeting and everything. But now the problem will occur when Okay, whether the ABC can protect its interest. Yes, definitely it can protect its interest through enrichment provisions. So if they would have decided beforehand that the decisions will be taken by the majority or 90% or like that, so that the minority shareholders' interest can be protected. These provisions are called as enrichment. So 100% enrichment provisions can be there in case of the private limited company. But in case of the public limited company, it is limited to special resolution. Means you cannot have the 100% approval. Okay, that is practically not possible in the listed companies. So that is the reason the enrichment provisions are allowed to the extent of special resolution in case of public limited companies. So these are the important points. Okay, you should remember relating to the AOA. Okay, if the question is asked, we should be in a position to write down. Okay, so now we can just quickly go through which can be the contents of the AOA. I'm using the word which can be because it may differ from company to company. Contents of AOA. Contents of AOA. Okay. So just to name few contents, we can say that adoption of preliminary contract. Adoption of preliminary contract. Okay, number and value of shares, not number and value of shares. Issue of preference shares, allotment of shares, allotment of shares, calls on shares, lien on shares, transfer and transmission of shares, then nomination provision, forfeiture of shares, forfeiture of shares, then one can have provisions relating to the alteration of capital, alteration of capital. Then there can be buyback provisions, buyback provisions can be there. Okay, there can be provisions relating to the share certificate, there can be provisions relating to the share certificate, then voting rights and proxies, meetings provision can be there, and regarding committees, directors, their appointment and delegation of powers, managing director provision, full-time director, manager and secretary. Then there can be provisions relating to the additional director, common seal, directors and general meetings, directors and general meeting, and last winding up. See, there can be more provisions also. I have just noted few very important regulations which you get in the MOA. So like adoption of the preliminary contract. So preliminary contract is nothing but the pre-incorporation contract. So how it should be adopted, the number and value of shares, preference shares issue कैसे हो सकता है, how the shares should be allotted, calls on shares, lien on shares, how the transmission of the shares will take place, nomination, forfeiture of shares, alteration of capital, how the buyback will happen, like company buys back its own shares. Then the share certificate related provisions. So whenever there are physical share certificates, how the share certificate should be transferred, or the transfer should take place. So when the transfer happens, the share certificate also should be handed over to the new shareholder. How that procedures will take place. If any case of the loss certificate, duplicate share certificate, how it can be given. Voting rights can be decided. The rights regarding the proxies can be decided. The meetings and the connecting rules regarding committee meetings and the meetings of the company, directors and their appointment, delegation of their powers, MD, WTD, manager, secretary related, like key manager persons' powers can be defined. Additional directors provision can be defined. Common seal, how to use it, who should authenticate the common seal, attach the common seal and all that. Directors and its general meetings can be defined. Provisions relating to that, and winding up provisions. So these are all important provisions you will find in most of the cases. Over and above that, or it may be curtailed also to some extent by the companies. So these are the standard provisions for most of the times we find in the articles of association of the company. Now we have talked about the articles of association. When we say that how the articles should be amended, or whether there can be provision relating to the alteration of articles of association, the provision is given under section 14 of the Act. What does it mean? Alteration, we have already studied. And if a company wants to go for alteration, what company has to do? Special resolution is required. Special resolution is required. So like in case of the company memorandum of association, company may have to go to the central government for few alterations. That is not the case with the alteration of articles of association. So special resolution is sufficient in that particular case. So along with special resolution, then it should be intimated to ROC within a timeline. ROC should be informed properly that we have made such alterations. And then along with that, company has to company has to mention the details of alteration. Mention details of alteration, like when the alteration was made, okay, on the bottom of page of the MOA and AOA copy, normally you get all those alterations, okay, provisions. So and so provision was changed on so and so date during this particular meeting. So all these particular provisions have to be properly maintained by the company. So this is about alteration, not that difficult like in case of the memorandum of association of the company, where we have various provisions and the various clauses can be altered in a different way. But here it is a standard provision that you need to pass a special resolution of the general meeting, because it is the purview of the shareholders. It comes under the purview of the shareholders. So shareholders only can take the decision for the alteration of articles of association. Now let's talk about, okay, you may just note down so far whatever we have done. We have completed the articles of association, so please note down all the provisions. Okay. I hope you understood all these provisions. In contents of the AOA. So all these are the provisions which can be incorporated in articles of association. Then we talk about alteration of articles of association. So here we have completed two important topics, very important topic from exam point of view, memorandum of association and articles. So can we make the differences? Can we make out some different points between all these two important documents? Yes, definitely yes. So let's try to identify the different points between MOA and AOA. Let me just put a divider between this. So like, okay, first we may talk about MOA. I'm just using the short form. I hope you are now very comfortable with this short form MOA and AOA. Okay, so what can be the differences? Okay, so the first difference always should be the definition you can write down. Okay, apart from that, you can write down the first point of difference. It is charter of company. It is charter of company. And what about this? Rules and regulations. We can say rules and regulations of company. Rules and regulations of company. Okay, so we have talked multiple times that MOA, okay, is a kind of charter for a company, and the AOA is the rules and regulations of the company. So you can just put the line on these particular important points. So what about the alteration? The clauses of MOA cannot be easily altered. Okay, clauses of MOA cannot be easily altered. But what about this? Yeah, you can say the clauses also, you can use the word clauses of AOA can be easily altered. See, we have seen this particular provision, okay, that the alteration MOA is very different than alteration of AOA. So in case of the alteration of MOA, you have the various clauses like name clause, register office clause, object clause. So like that, okay, we have seen various provisions relating to the alteration as well, but here the set principles are there. So only shareholders approval is required. You don't have to go to the central government for that particular reason. MOA is subsidiary MOA is subsidiary to which act? Companies Act. But here you can write down that AOA is subsidiary to Companies Act and Memorandum of Association. So it is subsidiary to both Companies Act and Memorandum of Association. What about MOA? It is subsidiary to Companies Act. So you cannot have the provisions which are going contradictory directly to the Companies Act. So in a case of the AOA, the contradiction, okay, is for both. You cannot have the contradictory provisions of the Companies Act and MOA. See, but that does not mean that, okay, you cannot have the restrictions laid down under the Articles of Association. That particular provision is very well, okay, there. What generally is defined by the MOA, okay? MOA generally defines the relation between the company and outsiders. So what does it define? The relation between company and outsiders. But what about the AOA? it regulates it it regulates the relationship between the company and its members. So basically a company and its members. So this is called as the internal document for the internal management of the company. So this document establishes a kind of relationship between the persons inside. What about the MOA? Okay, it defines the relationship of the company with the outside world. Okay, so 4 point of differences we have completed. There are 2 more point of differences. Let's quickly complete those as well. Put over here MOA and AOA. Okay, MOA and AOA. Acts done by company beyond the scope of MOA are absolutely void and ultra virus. What is mean by that? Void and ultra virus means beyond the powers. Okay, this concept we have studied. We can say some of the acts of company, some of the acts done by company, we will use the same language, beyond AOA are irregular and can be ratified by shareholders. Irregular and can be ratified by shareholders. Okay, so acts done by the company, okay, in case of the MOA is ultra virus, void. Acts done by the company, okay, in case of the articles is irregular and cannot be ratified by the can be ratified by the shareholder. That's not all act which can be ratified, okay, can be done. It is not but possible absolutely in case of the MOA. Last point of difference can be a company can adopt MOA given under table A to E of schedule 1 of the act. Okay, here what you can write down, company can adopt AOA given under table F to J of Schedule 1 of the Act. Okay, so this is possible under MOA and AOA, that okay, you can have the table A to E and here table F to J of the Act. So these are the important point of differences. Very quickly we will go through the memorandum copy of one of the very famous company. The name of the company is Reliance Industries, the Memorandum of Association and Articles of Association. So you can find this is the certified true copy, which is certified by its group company secretary and chief compliance officer. So here, this is one of the best example. As we know, okay, Reliance Industries is one of the topmost company in India right now in considering this net worth. The phrase certificate of incorporation, what all certificates they have registered, certificate of registration of order, okay, for transfer of register office, the order of the confirming transfer of register office. So they have transferred the register office, okay, to Karnataka, then Karnataka to Maharashtra. On the name change of the earlier the name of the Reliance Industries was Mine Lawn Limited, and then it was called as, it is now called as Reliance Textile Industries Limited, commencement of business and all that. The name of the company, then articles, see how it is written. You can see the provisions, okay, they have given the provisions, clauses, regulation number and the page numbers. See, lien on the shares, call on shares, all these points we have discussed, but these are okay discussed in detail over here. Alteration of capital, then joint holders, capitalization of profit, what can be the buyback provisions, okay. Then at the same time the general meeting provisions are also given. Proceedings of general meetings, what will happen in case of the adjournment of the meeting. So here you can find the provisions, voting rights, proxy, board of directors provision, duration of additional directors, powers of the board, proceedings of the board, particulars like question at board meeting, how decided, okay, how the decisions will be taken. See, chief executive officer, company secretary, CFO, manager, these are all key managerial persons, their provisions. Registers, statutory register, foreign register, how the seal, okay, where the custody will of the seal, how the seal will be affixed, dividends and reserves, accounts, winding up, indemnity and insurance, and general power. So these are some of the annexures, okay, because see, this company has been into various, there are various amalgamations happening, okay, between the Reliance Industries and other companies. So whenever the amalgamation happens, the court order you need to affix to the memorandum of association. So certificates, you can see the certificate Reliance Textiles Industries Limited, now it is called Reliance Industries Limited. So it was changed to Reliance Industries Limited, earlier it was Reliance Textiles Industries Limited. कब चेंज हुआ? 1985 में चेंज हुआ. Here you can see. Okay, it was changed in the year 1985. Okay, so now the name of the company is Reliance Industries Limited. Earlier that company name was Reliance Textiles Industries Limited. So you can see. When the register office was changed, so when the register office changes, okay, the certificate was given in the year 1977. This was the order, okay, given by the, yeah, this is very important. This is certificate of incorporation. Certificate of incorporation. So for very few people know that Reliance, the company's name was earlier Minlon Limited, okay, which was registered earlier. So this is the, now we are starting with the memorandum of association. So this is my first clause, that is name clause of the company, which is Reliance Industries Limited. Second clause is register office will be situated in state of Maharashtra. The object clause, okay, company is established for the following. Object clause is very important, as I told you, it goes into pages. So see, you can see over here there are main objects of the company defined. So company can do so many things, so you can find out the so many objects of the company. So like business of manufacturer, dealers of all kind, fibers and all that. Then into the finance, various other things also they are into the business of. See, after that you get the ancillary or incidental, which are connected to the main object to attainment. See, what are the ancillary object? To attainment of the main object, to attain the goals of the main object, you require ancillary object. So like to enter into agreements with various persons, like that. Okay. We can go on. Then we have the other objects not included under A and B. Other objects not included under A and B. So after that, here the fourth number clause you can see, okay, limited liability clause. It is liability is limited. Then the fifth number clause is capital clause with authorized share capital. See, what is the share capital of the company? Authorized share capital, it is 15,000 crores of rupees. 15,000 crores only, consisting of 1,400 crores equity shares and 10,000. See, it is equity shares and preference shares divided into 100 crores preference shares. See, end notes are required to be given whenever any changes happen. So you need to give the end notes like this, okay, when it was inserted and all that. The authorized share capital of the company at the time. Kitna tha authorized share capital of the company at the time of incorporation is what? 3 crore 75 lakhs. Now it has become, see, 15,000 crores of rupees over a period of time. From 77 till now. So original share capital at the time of incorporation was this much. Now, okay, in the year 17, okay, now this much. Okay, this is called as subscription clause. Okay, so you get the information of subscribers over here. Who are the subscribers, their address, description, how many shares they had taken and witness. Kab hua tha subscription? Okay, see that. Articles, okay, we have already gone through this particular list. Okay. So these go in pages. As you can see, articles is a very lengthy document in nature, okay, and they have attached various high court orders, sanctioning arrangements and amalgamations. So if you have not written this, please make a note of all these important points of MOA and AOA very quickly. So these are the 6 points of differences between memorandum of association and articles of association. So students, that's it from today's session. We have understood the very important concept of articles, and we have also at the same time compared the different points between the MOA and AOA. We have also gone through one of the very important document of the company, Reliance Industries Limited, okay, document of Memorandum of Association and Articles of Association. I hope you have understood all the provisions we have studied today. Please do watch this video, prepare yourself, read the notes, okay, and make notes from time to time. So that's it from my end today, okay. We'll meet again with a new topic. Thank you so much for attending this particular session. Goodbye.